The judge set down her reading glasses and looked across the courtroom at the attorney representing Heritage Valley Bank. Her name was Judge Sharon Caldwell, and in 32 years on the bench, she'd seen a lot of questionable foreclosures. But this one was different. Mr. Patterson, let me make sure I understand correctly. The bank's attorney, Richard Patterson, straightened his tie. Yes. Your Honor, your client foreclosed on a 220-acre farm because the owner owed $6,000 in property taxes? That's correct. And you sold that farm at auction for $68,000? Yes, Your Honor. The proceeds were applied to the tax debt and associated fees. Judge Caldwell picked up a document from her desk. And you're aware that this property has been in the Callahan family since 1947. We are aware of the property history, yes? Then perhaps you can explain to me why your client didn't notice that the property was held in an irrevocable family trust established in 1958. Richard's face went pale. I'm sorry, Your Honor. A what? Judge Caldwell held up the document, a trust, filed with this court 66 years ago, making the property exempt from foreclosure for unpaid taxes. Your Honor, I wasn't aware. Clearly. She looked toward the back of the courtroom, where a 76-year-old man named Owen Callahan sat quietly beside his attorney. Mr. Callahan, please approach. Owen stood slowly, his hands shaking. He'd lost his farm 3 months ago, been evicted, forced to move into a trailer on his daughter's property. He'd given up until a court clerk, going through old land records for an unrelated case, stumbled across a dusty file box labeled Callahan Family Trust, established 1958, and everything changed. Owen Callahan had lived on the same 220-acre farm his entire life. His grandfather, Thomas Callahan, bought it in 1947 with money saved from working in the steel mills. His father, Raymond, took it over in 1971. And when Raymond passed away in 2003, Owen inherited it. Or so he thought. Owen was never a wealthy man. He raised cattle, grew hay, and did odd jobs to make ends meet. His wife Linda passed away in 2017. After that, Owen struggled. He couldn't keep up with repairs, couldn't afford new equipment. And slowly, he started falling behind on property taxes. By 2022, Owen owed $6,000 in back taxes. The county sent notices. Owen ignored them. Not out of defiance, out of shame. He didn't have the money, and he didn't know what to do. In early 2023, the county turned the debt over to Heritage Valley Bank, which had a contract to collect delinquent taxes through foreclosure. The bank sent Owen a final notice: pay $6,000 by March 15, 2023, or face foreclosure. Owen called his daughter, Rachel, in tears. I don't have it. Rachel scraped together $4,000 from savings and begged the bank for an extension. They refused. On April 3, 2023, Heritage Valley Bank filed for foreclosure. Owen received a court summons. He didn't understand the legal language. He didn't hire a lawyer. He just sat at his kitchen table, staring at the papers. On May 12, 2023, the court granted the foreclosure. The farm was scheduled for auction on June 1, 2023. Owen stood outside the courthouse steps, watching strangers bid on his family's land. The auctioneer's voice echoed. Do I hear 60,000? A hand went up. 65? Another hand. 68,000. Going once. Going twice? Sold. The buyer was a local developer named Mark Hastings, who planned to subdivide the land for residential lots. Owen walked to his truck and drove home in silence. 2 weeks later, the sheriff arrived with an eviction notice. Owen had 30 days to vacate. Rachel helped him pack. They loaded photos, furniture, and a few boxes of family records into a U-Haul. On his last day, Owen stood in the doorway of the farmhouse and looked back. I'm sorry, Dad, he whispered. Then he locked the door and left. Owen moved into a single wide trailer on Rachel's property. He stopped eating, stopped talking. He just sat on the porch, staring at nothing. Rachel was terrified he'd give up completely. Then one afternoon in August 2023, she got a phone call. The voice on the other end was unfamiliar. Is this Rachel Callahan? Yes. My name is Dorothy Klein. I'm a clerk with the Iron County Probate Court. Okay. I'm calling about your family's property, the farm on County Road 84. Rachel's chest tightened. We lost that property. It was foreclosed, I know. But I think there may have been a mistake. Dorothy explained that she'd been digitizing old probate records when she came across a metal file box from 1958. Inside was a legal document, Callahan Family Irrevocable. Trust established November 14, 1958. Grantor, Thomas Callahan. Trustee, Raymond Callahan. Beneficiaries, Raymond Callahan and all lineal descendants. The trust document stated that the 220-acre farm was to be held in perpetuity for the benefit of the Callahan family and could never be sold, mortgaged, or seized for debts. Dorothy read it 3 times, then she called Rachel. Rachel drove her father to the probate court the next day. Dorothy led them into a back room where old filing cabinets lined the walls. She pulled out the file box and opened it. Inside were the original trust document assigned, affidavit from Thomas Callahan, a filed copy with the probate court seal, a certificate of acceptance. Owen stared at the papers, his hands trembling. What does this mean? Dorothy looked at him gently. It means your grandfather protected this farm. He set it up so it could never be taken from your family. But they already took it. I know. But if this trust is still valid, that foreclosure shouldn't have happened. Rachel grabbed her father's hand. We need a lawyer, Rachel. Contacted Legal Aid of Southeastern Ohio and was connected with an attorney named Marcus Riley. Marcus was in his early 50s, a former public defender who now specialized in property rights cases. When Rachel showed him the trust documents, his eyes widened. Where did you find this? A probate clerk. She was going through old files. Marcus read the document carefully, then he looked up. If this trust is valid, the foreclosure is void. Can you help us? Marcus nodded. We file an emergency motion to set aside the foreclosure and restore ownership. Will it work? If the court recognizes the trust? Absolutely. On September 8, 2023, Marcus filed a motion to vacate foreclosure judgment in Iron County Common Pleas. Court, the motion argued, the property was held in an irrevocable trust since 1958. Trusts are exempt from tax foreclosure under Ohio law. The bank failed to verify ownership structure. The foreclosure and sale are void. Heritage Valley Bank's response was aggressive. Heritage Valley hired a Columbus law firm. Their attorney, Richard Patterson, filed a response arguing the trust was created 65 years ago and may no longer be valid. Owen never disclosed the trust's existence. The bank relied on public records showing Owen as owner setting aside the sale would harm an innocent buyer. At the end of the brief, Richard wrote, the plaintiff had ample opportunity to raise this issue before the foreclosure. He cannot now use a forgotten trust to undo a legally completed sale. The hearing was held on October 17, 2023. Judge Sharon Caldwell presided. The courtroom was packed. On one side sat Owen, Rachel, and Marcus. On the other sat Richard Patterson and 2 executives from Heritage Valley Bank. In the back sat Mark Hastings, the developer who'd bought the farm at auction. Judge Caldwell reviewed the trust document silently for several minutes. Then she looked up. Mr. Riley, when was this trust filed? November 14, 1958, Your Honor. And it's been on file with the probate court this entire time? Yes, ma'am. Mr. Patterson, why didn't your client check for this before foreclosing? Richard stood. Your Honor, we relied on the deed records, which showed Owen Callahan as the sole owner. Did you check the probate records? No, Your Honor. Did you search for any trusts, liens, or encumbrances? We conducted a standard title search. That's not what I asked. Richard hesitated. No, Your Honor. We did not specifically search probate records. Judge Caldwell set the document down. Continue. Mr. Riley, Marcus stood. Your Honor, under Ohio Revised Code, Section 5723-01, property held in an irrevocable trust is exempt from foreclosure for unpaid property taxes. This trust was established in 1958. It's been on file for 65 years. The bank had a legal obligation to search for it. They didn't, and because of that failure, my client lost his family's farm. He placed the trust document on the projector. This document is clear. The property cannot be sold, mortgaged, or seized, ever. Richard stood. Your Honor, even if the trust is valid, Mr. Callahan never mentioned it during the foreclosure proceedings. He had a duty to disclose. He didn't know it existed, Marcus interrupted. Judge Caldwell looked at Owen. Mr. Callahan, did you know about this trust? Owen stood slowly. No, ma'am. My father never mentioned it. I thought he just left me the farm. When did you first learn about the trust? 2 months ago, when the court clerk called my daughter. Judge Caldwell nodded. Sit down, Mr. Callahan. She looked at Richard. Your argument fails. He can't disclose something he doesn't know about. Marcus called a trust and estate attorney as an expert witness. The expert testified that the 1958 trust was properly executed and filed. It remained valid unless formally dissolved property held in such a trust is legally exempt from tax. Foreclosure. The bank's failure to search probate records was a critical error. Richard had no effective cross-examination. Mark Hastings, the developer who bought the farm, asked to address the court. Your Honor, I paid $68,000 in good faith. I've already invested another $40,000 in surveys and permits. If you void this sale, I lose everything. Judge Caldwell looked at him sympathetically. Mr. Hastings, I understand, but you bought property the bank didn't have the right to sell. That's not my fault. No, it's the bank's fault, and you'll need to take that up with them. Judge Caldwell took 3 days to issue her decision. When court reconvened, the room was silent. Owen sat beside Marcus and Rachel, barely breathing. Judge Caldwell put on her glasses and began reading. This court has reviewed the trust document, the foreclosure record, and applicable Ohio law. The Callahan Family Trust was properly established in 1958 and remains in effect. Under Ohio law, property held in an irrevocable trust for family benefit is exempt from foreclosure for unpaid taxes. She looked at Richard. Heritage Valley Bank had a legal duty to search probate records. They failed to do so. As a result, they foreclosed on property they had no legal right to take. The foreclosure is void. Owen's eyes filled with tears. Ownership of the property is restored to the Callahan Family Trust. With Owen Callahan as trustee, the sale to Mr. Hastings is reversed. The bank will refund his purchase price plus documented expenses. Furthermore, Heritage Valley Bank will pay Mr. Callahan's attorney fees and any costs incurred during his wrongful eviction. The gavel fell. Rachel grabbed her father's hand. Owen broke down sobbing. 2 weeks later, Owen stood in the driveway of the farmhouse. The keys were in his hand. Rachel stood beside him. You ready, Dad? Owen nodded, unable to speak. They walked to the front door together. Owen unlocked it and stepped inside. Everything was exactly as he'd left it. He walked through the house slowly, touching the walls, looking out the windows. When he reached the back porch, he sat down and cried, not from sadness, from relief. Heritage Valley Bank quietly settled with Mark Hastings, refunding his money and covering his losses. The bank also paid Owen $23,000 in damages and moving costs. Dorothy Klein, the probate clerk who found the trust, received a commendation from the county. And Owen? He lived on the farm for 6 more years before passing away peacefully in 2029. He left the property to Rachel, and when she filed the new trust documents, she made sure every single record was cross-referenced, digitized, and impossible to lose. In 2024, Ohio passed a law requiring all foreclosing entities to search probate, trust, and estate records before seizing property. It was called the Callahan Act, and on the wall of the Iron County Probate Court, there's now a small plaque, in memory of Thomas Callahan, who in 1958 had the foresight to protect his family's future. Owen. Callahan didn't lose his farm because he owed money. He lost it because a bank didn't do its homework. They saw $6,000 in unpaid taxes, and they saw an opportunity. They never bothered to check if the land could even be taken. But buried in a dusty file box, in a basement office, in a document older than most of the people in that courtroom, was the truth. A grandfather's promise, written in 1958, that his family would never lose this land, and 65 years later, that promise saved his grandson, because some things are worth more than money, some things are protected by more than fences, and some promises even after decades, still have the power to bring a man home.